Suit number NICN/LA/434/2017 between Mr. Iyun Julius and First Trustees Limited and Nigeria Law Publication Limited. My lord, the parties are absent.
Okay. Representation of counsel. Representation of counsel. It appears.
Well, I saw Mr. Akinbade Dada online a few minutes ago.
He just left. He just left. He was online now.
Okay. I believe your notices were served on the parties. This case was adjourned today for judgment. You have notice the sitting day was served on the parties, and in their absence, I would proceed and read the judgment. I will read the introduction, claim, the breakback for the case, keep the submission of counsel and the decision portion. Goes this way. The claimant instituted this suit against the defendants seeking for the following reliefs. A declaration that by the ruling of the Chief Magistrate Court number 4 Ikeja 20th May 2016, issued number MIK/1/10/2010 between Commissioner of Police and Said Aino and 3 others, discharging the claimant on a no-case submission, the claimant's indefinite suspension be withdrawn and be reinstated to his post as a marketing manager of the second defendant company. B, a declaration that the claimant, having been so discharged, is entitled to his salary in arrears with allowances from the date of the indefinite suspension, i.e. from 1st of February 2010 to 10th of May 2016. C, a declaration that the arraignment of the claimant was wrongful, nothing but an act of vendetta, unjustifiable victimization and persecution. D, an order compelling the defendant to withdraw the claimant's indefinite suspension and reinstate him back to his duty post. E, an order compelling the defendant to pay to the claimant the salary arrears and leave allowances from February 2010 to May 2016 in the sum of 7,524,000. F, an order awarding damages in favor of the claimant to the tune of 5 million naira against the defendant for malicious prosecution and for the trauma suffered from the defendants by the claimant from the defendant's action. The facts leading to this case, as can be gathered from the pleadings filed by the parties, arose out of a high-scale fraud detected at the defendant's warehouse involving some members of staff, including the claimant. The claimant and 7 others were indicted based on the audit report and were charged before the Ikeja Magistrates Court. During the course of the proceedings, there was a legal advice from the Director of Public Prosecution Ministry of Justice, Lagos State, directed that one of the persons charged to court be discharged and acquitted, while the remaining 6 be taken to the High Court of Lagos State to face trial there. Notwithstanding the legal advice, the latter trial magistrate complied with the only first leg, with the first leg of the legal advice by discharging the said staff and disregarded the other instructions given in the legal advice. The court then subsequently discharged and acquitted the claimant and 6 others. Discharged and acquitted the claimant along with 5 other staff, including The court then subsequently discharged the claimants and 5 other staff following a notice submissions made on their behalf. Based on the said on the said ruling, the claimant approached this court claiming for the reliefs I mentioned earlier. I now skip the submission of counsel and read the decision. After careful consideration of the processes filed, the evidence adduced, and the submissions of counsel with the authorities cited in support in the final addresses, I shall start off with the ruling over the defendant's preliminary objection. The defendant raised a preliminary objection challenging the jurisdiction of this court to entertain the claimant's case on the following grounds. 1, that the first defendant is not known to law. Proposed defendant also is not capable of defending this case. Hence, he is not a proper party. It is not a proper party to this suit. 2, that this honorable court does not have the jurisdiction to hear and entertain the claimant, the claim by the claimant's claim, and the claim arose from the ruling of magistrate courts that lacked jurisdiction over the matter. 3, that the purported ruling, which is the bedrock of this case, is being challenged at the High Court of Lagos State, Ikeja Division, in suit number ID 1630/MJR/17, at the magistrate court in defiance of the Director of Public Prosecution's legal advice, proceeded with the matter while there was want of jurisdiction and purportedly dismissed the charge and discharged the claimant when the court lacks the capacity to do so. 4, that there is an appeal for judicial review over the matter, and the claim is premised on the decision by a magistrate court that lacks jurisdiction to dismiss the charge and discharge the accused persons, claimants in this case. 5, that until the claimant is discharged and acquitted by a court of competent jurisdiction, this honorable court lacks the jurisdiction to entertain this claim. That this honorable court has no jurisdiction to hear and entertain the claimant's claim that borders on malicious prosecution, as it is outside the enabling power of this court. Now, the PO is supported by 24 paragraphs affidavit and a written address in which the defendant formulated 3 issues to be determined by this court. In reaction, the claimant filed a 7 paragraphs counter affidavit and a written address on the 11th of October 2017, in which the claimant submitted 3 issues for determination. The defendant, in reaction to the claimant's written address in support of the counter affidavit, filed a reply on point of law on October 18, 2017, in which they again formulated 3 issues for determination. I have carefully examined the processes filed by the parties, the argument canvassed, and the authorities cited in support regarding the preliminary objection. The crux of the defendant's argument, the crux of the post-dependent argument is that it is not known to know as such and as such not a proper party to this suit. That the said claimant, that the claimant's case is predicated on the ruling of a magistrate court delivered in the claimant's favor without jurisdiction, and that this robs this court of the jurisdiction to entertain the claimant's case. The fulcrum of the claimant's argument is that the present application is incompetent as it was brought without filing a memorandum of appearance by the defendants, that the claimant's case disclosed a reasonable course of action under the ruling of the Ikeja Magistrate Court remains valid until set aside by a superior court of competent jurisdiction. Now, it is on record that the defendants, upon being served with the originating process in this suit, reacted by filing this preliminary objection without first filing a memorandum of conditional appearance, which is the condition precedent to defending an action in this court. See Order 18, Rule 2, Sub-Rule 4 of the extant rules of this court. Now, the defendants have filed a memorandum of conditional appearance on October 18, 2017, which I think has cured the defect observed by the claimant in this regard. So the claimant's argument is therefore overtaken by events. Regarding the first defendant's status, there is nothing in the statement of facts to disclose a reasonable course of action against the first defendant in this. This being the case, the first defendant's name is hereby struck out. I find and I so hold. Regarding the disputed ruling delivered by the Ikeja Magistrate Court, discharging the claimant of the allegation of stealing, among others, I am in total agreement with the argument of the learned counsel to the claimant in this regard, that the said ruling, having not been set aside by a competent superior court, remain valid and subsisting. The claimant is therefore right in relying on the said ruling to bring this action. The jurisdiction of this court does not extend to sitting on appeal over decisions of a magistrate court, as the defendant's argument seems to suggest. See Section 254C of the Constitution of the Federal Republic of Nigeria, 1999. For all the foregoing reasons, I find that the defendant's preliminary objection succeeds only in terms of the propriety of the joinder of the first defendant hearing. Now, during trial, the defendant raised objection to the admissibility of Exhibit CWF, which is the defendant's solicitor's reply to the claimant's solicitor's letter, dated the 24th of October 2016, on the ground that the said exhibit was marked without prejudice. This court therefore directed the defendant to incorporate the said objection into its final written address, and the defendant did so. The claimant did not file final written address in this case, in which he could have reacted to the objection. Now, I have carefully examined Exhibit CWF, and I find that it was marked without prejudice. It is the law that a statement made without prejudice during negotiation cannot be admitted in evidence. I refer to the case of Kanyip and MBA and others, Ashakasem PLC against Asharul Mubashirun Investment Limited and Mwadike and Idigbe. Citation supplied. This being the case, I find that Exhibit CWF is inadmissible and same is discountenanced for the purpose of this judgment, and I so hold. At the close of the claimant's case, the defendant rested its case on that of the claimant. It is the law that where a defendant rests his case on the claimant's case, it means one of the three things. Either one, that the defendant is stating that the plaintiff has not made out any case for the defendant to respond to, or two, that the defendants admit the parts of the case as stated by the plaintiff, or 3, that the defendants has a complete defense in answer to the plaintiff's case. I refer to the case of Deck Oil and Gas Limited against Shell Nigeria Gas Limited and another. Citations of light. In the instant case, the defendant rested his case on the claimant's case on the ground that the claimant has not made out a case for the defendant to respond as rightly submitted by the learned counsel to the defendant. The case was accordingly adjourned to a later date for adoption of final written address. The claimant, despite with the opportunity given to him, failed to file his written address, to file the written address. Consequently, the claimant's right to file written address was accordingly foreclosed, and the defendant later adopted its final written address. As it is, this case is going to be determined on the strength of the pleadings of the parties, evidence adduced by the claimant, and the defendant's final written address. The law issue calling for the determination of this court is therefore whether the claimant has proved his entitlement to any or all the reliefs sought. The claimant averred at paragraph 3 of the statement of fact that he was engaged into the services of the defendant on January 6, 1989. He also averred at paragraph 4 that he was promoted to the post of head driver, and at paragraph 5, claimant averred that he continued to act in that capacity until February 15, 2010, when he was placed on an indefinite suspension without pay, along with others, ending the determination of charges of conspiracy and stealing filed against them at Ikeja Magistrate Court, of which the claimant was discharged along with others following a ruling over a notice submission made on their behalf. See paragraph 6 of the statement of facts. Now, the defendant denied having any employment relationship with the claimant at paragraphs 1 and 2 of the statement of facts. These therefore place the onus on the proving the existence of employment relationship on the claimant's shoulder. The claimant did not tender his letter of appointment or any evidence of his appointment as the head driver. When asked under cross-examination, the claimant admitted that he was a personal driver to the chief and to the late Chief Gani Pawahim, that he served him 20 years, which he was rewarded with a gift of Toyota Light X, that his letter of employment and the letter of promotion were lost, and that he was not personally served with a letter of suspension, and same was not addressed to him, but was pasted on the entrance gate of the company, that is the defendant. Claimant tendered Exhibit G, the evidence of transfer of ownership of the same Toyota Light is signed by the defendant's chairman, the late Chief Gani Pawahim, and Exhibit CWC, that is the internal memo of the defendant notifying the general staff of the allegations against the claimant and other staff, and their indefinite suspension duly signed by the defendant's senior executive officer. The defendant's argument in the final place is that from the evidence before this court, there is nothing to show that the employment relationship existed between the claimant and between the parties hearing, that the terms of the said employment relationship have not been pleaded, so also the data of employment, that the contract of service cannot be presumed, and that the transfer of gift cannot suffice as employment contract. That a personal driver to the defendant's chairman cannot form part of the defendant's staff, and that the claimant's position was no more than that of a domestic staff of the defendant's chairman. Now, regarding the importance of the letter of appointment, in the case of Organ against Nigeria Liquefied Natural Gas Limited and another, the Supreme Court by ACAS JSC held at page 57, paragraph C to E, thus diagnosed. The letter of employment is the bedrock on which any of the appellants can lay claim to being employees of the school. And without the production of such document, no employment can be imparted. End of. It is the law that the relationship between the employer and employee is generally to be found in the service agreement or letter of employment. See the case of Anaja against UBA, citation supply, where a claimant fails to plead and prove the fact of his employment in a contract of service, he will not be entitled to a declaration that the appointment subsists. See the case of Morohum, Pola, and Kwara State College of Technology. The only exception is where the defendant admits the existence of the contract as well as the terms and conditions thereto. In the case of UBA, Ubani and UBE, citations of like. In the case, the claimant admitted under cross-examination that he does letter of employment in relationship with the claimant. But the claimant failed to tender evidence to show, to plead evidence to show that there was indeed employment relationship between himself and the defendant, and failed to plead and prove the existence of employment relationship. I think the case of the claimant is robbed of any competence. And this being the case, I find that the claimant's case lacks merit and same is hereby dismissed.
Please. Please, my lord. Please.
Next. The next case, I think the registrar is not with us. The next case is between Mr. Ajibadi Adepowoju. The next case is suit number NICN. Suit number NICN LA 451-2017 between Mr. Ajibadi Adepowoju and Post Trustees Limited to Nigeria Law Publications Limited.
Present, my lord.
Present. Is there, sir? Parties present, sir. Defendant representative, my lord.
Okay. Who is representing the defendant?
Yes, sir.
Is the claimant in court?
The claimant is not. Defendant is represented by.
Mr. Patrick.
Yes. By Mr. Patrick Okpanachi.
Yes.
Patrick Okpanachi.
Okpanachi,
my lord. Yeah.
Patrick
Okpanachi.
Okay.
Yes, my lord.
Okay. Representation of counsel.
May it please the court. Akin Baridada for the defendants.
Yes. Any appearance for the claimant?
No, my lord.
Judgment is ready and will be delivered in open court. I read the introduction, the reliefs, the submissions of counsel, and read the decision portion. goes this way. The claimant commenced this suit before this court via a general form of complaint, statement of facts, and the accompanying originating processes. Pray for the following reliefs. E, a declaration that by a ruling of the Chief Magistrate Court number 4, Ikeja, of 20th May 2016, in suit number MIK/1/10/2020, between Commissioner of Police and Said Aino and 3 others, discharging the claimant on a no-case submission, the claimant's indefinite suspension be withdrawn and be reinstated to his duty post as the marketing manager of the second dependent company. B, a declaration that the claimant, having been so discharged, is entitled to his salary arrears with allowances from the date of the indefinite suspension, that is 1st of February 2010 to 10th of May 2016. C, a declaration that the arraignment of the claimant was wrongful, nothing but act of vendetta, unjustifiable victimization, and persecution. D, an order compelling the first and second defendant to withdraw the claimant's indefinite suspension and to reinstate the claimant as the marketing manager. E, an order compelling the first and second defendant to pay salary arrears and leave allowances of the claimant from February 2010 to May 2016 in the sum of 6,160,000 naira. F, an order awarding damages in favor of the claimant in the sum of 5 million naira against the defendant for malicious prosecution and for the trauma suffered by the claimant resulting from the defendant's action. The claimant, the brief part of the case. The claimant alleged that he was employed by the defendant at the personal drive as a marketing manager. I think I mixed up the part. The claimant was employed by the defendant as a marketing manager. The claimant was employed by the defendant as a marketing manager. The defendants auditors came for a physical stock taking and made some recommendations. Subsequently, a high-scale fraud was detected at the defendant's warehouse involving some members of staff, including the claimant. The claimant and 7 others were indicted based on the audit report and were charged before the Ikeja Magistrate Court for conspiracy and stealing. However, during the pendency of the proceedings, there was a legal advice issued by the Office of the Director of Public Prosecution directing that the claimants, one of the claimants be discharged and the remaining ones be arraigned before the Lagos State High Court. After discharging one of the suspects, the Lana trial magistrate went ahead and assumed jurisdiction over the matter. At the close of the prosecution's case, a no-case submission was made on behalf of the claimant and 5 other accused persons, which the Lana trial magistrate upheld, consequent upon which the claimants and 5 other persons were discharged. Having been discharged by the ruling of the Lana trial magistrate, the claimant filed this case claiming for the relief I mentioned earlier. I will now skip and read the decision. Read the decision portion. After careful consideration of the processes filed, the evidence adduced, and the submissions of counsel with the authorities cited in support and the final written addresses, I now start with the ruling over the defendant's preliminary objection. The said preliminary objection was also filed in the case I just delivered judgment in respect of, and in order to save time, I will skip the ruling over the said preliminary objection, as all the reasons stated in the other case are applicable here. Counsel will obtain the ruling along with the judgment when it is ready. I will proceed to read to determine the case. I have carefully examined Exhibit CWF. In summary, I uphold the preliminary objection only in terms of the impropriety of the joinder of the first defendant, and the name of the first defendant is accordingly struck out from this case, this suit. But all the other grounds of the objection are dismissed. I now proceed with the claimant's case. The defendant raised objection in the course of trial to the admissibility of Exhibit CWF. The defendant's reply to the claimant's solicitor's letter dated October 24, 2016, on the ground that the said letter is marked without prejudice. The claimant's reaction is that this court should discountenance with the defendant's objection because Exhibit CWF is relevant to the fact in issue in this case, hence admissible, and it supports the claimant's case. I've carefully examined Exhibit CWF, and I find that it is so marked without prejudice. It is the law that a document marked without prejudice, or even where it is not so marked in plain language, but same is implied in a negotiation conducted in a documentary form, or verbally, remain inadmissible in law. See Ashaka Cement versus Asharul Mubashirun Investment Limited. This being the case, I find that Exhibit CWF is inadmissible and is accordingly discountenanced. I so hold. The defendant also objected to the admissibility of Exhibit CWC, that is the defendant's internal memo to its members of staff, dated February 15, 2010, informing the staff that the claimant, among other staff, were suspended indefinitely. The ground of the said objection is that the said document is a copy, and no foundation was laid by the learned counsel to the claimant when it was tendered. The claimant's reaction in this regard is that the said exhibit is relevant to the fact in issue, and it is also admissible to the claimant. It's admissible in this case. Now, the defendant did not challenge the authenticity of Exhibit CWC. It is only attaching the exhibit for it having been tendered as a copy without laying proper foundation in accordance with Section 89 of the Evidence Act. This code is a specialized code, and it has been enjoined by the Act establishing it, that is the National Industrial Code Act 2006, under Section 12, Sub 2, Subparagraph B, to depart from the provisions of the Evidence Act where the interest of justice so demands. This provision is acknowledged under Section 3 of the Evidence Act 2011, which provides that nothing in the Act shall prejudice the admissibility of any evidence that is made admissible by any other legislation validly enforced in Nigeria. Given that the main reason for objection to the admissibility of the CWC is its failure by the learned counsel to the claimant to lay foundation while tendering it, not on account of its authenticity, I am of the humble view that this is one of the instances where this court may depart from the provisions of the Evidence Act in the interest of justice. This being the case, the objection of the learned counsel to the defendant regarding the admissibility of Exhibit CWC is hereby overruled, and I so hold. The claimant did not raise I need to point out that the argument raised at paragraph 4.3 of the final written address regarding the claimant's witness statement on oath was never raised during trial by any of the parties. The said argument is accordingly discountenanced. During trial, the claimant told this court that he would be objecting to the admissibility of Exhibit D4. This court therefore directed the claimant to incorporate the said objection into his final written address in accordance with Order 15.4 of the extant rules of this court. The claimant did not raise the said objection in the final written address. I therefore take it that the claimant has abandoned same. I now turn to the merit of the claimant's case. The issue calling for the determination of this court is whether the claimant has proved that he was suspended indefinitely by the defendant, which suspension can be lifted. Which suspension can be lifted upon his discharge by the ruling of the Ikeja Magistrate Court. Regarding the status of the ruling delivered by the London Trial Magistrate, in which the claimant and other staff of the defendant were discharged from conspiracy and stealing following a notice of ruling of over a notice submission, the defendant's contention is that the said ruling was delivered without jurisdiction and therefore a nullity. The claimant's reaction is that this court cannot be invited to sit on appeal over the decision of the magistrate court because it is a specialized court whose jurisdiction does not extend to entertain an appeal over criminal matters, and that the judgment of the London Trial Magistrate subsists until same is set aside by a court of competent jurisdiction. Now, as rightly argued by the London Council to the claimant, the jurisdiction of this court does not extend to sitting on appeal over a decision of a magistrate court. Whether the ruling was delivered with or without jurisdiction is not for this court to decide. By Section 168 of the Evidence Act 2011, there is presumption of regularity attains to every decision or judicial act shown to have been substantially done in a regular manner. Accordingly, until set aside, such decision remains valid. I refer to the case of Mindy and State, Augustine and State, and Rose and others versus SCB Limited and others. The claimant contended that he was suspended indefinitely along with other staff of the defendant by Exhibit CWC. The defendant's reaction in this regard is that it did not suspend the claimant or any other staff over the allegation of stealing books or the subsequent investigation over the same allegation, and that Exhibit CWC relied upon by the claimant was a letter of warning addressed to all members of staff of the defendant in the form of internal memo, and thus cannot be relied upon by the claimant as evidence of his indefinite suspension. Now, suspension has been defined by the Court of Appeal in Galadima against Governor of Yobe State. Citations of light at page 14 to 17 per Onyema JCA. I skip the definition of the suspension of the council. Receive the judgment they can read it. I have painstakingly examined Exhibit CWC. I find that it is an internal memo from the defendant's senior executive officer to all members of staff of the defendant. It is dated February 15, 2010, with a subject title, "Without Prejudice." It reads thus, and I quote, "This is to inform all members of staff that the following individuals, namely Ide Otani, 2. Adeyemi Ayu. 3. Ajibade Adepowoju. 4. Adeboye Olusola. 5. Michael B. Filani. 6. Ian Julius. 7. Aina Saeed are hereby placed on indefinite suspension without pay, pending the completion of investigation and court case involving theft and stealing of books belonging to the Nigerian Law Publications Limited. These individuals are not to be found on company's premises within the group, company premises or within the group of companies, namely 1. Book Industries Limited, 2. Nigerian Law Publications Limited, 3. Gani Powahimi Chambers, 4. Gani Powahimi Library and Gallery. Anyone found collaborating with these individuals do so at their own peril. Signed, Saheed Powahimi, and end of quote. Now, the said exhibit is not addressed to the claimant in this case. It is addressed to all members of staff of the defendant as the warning. After stating that the claimant hearing, along with others, have been placed on indefinite suspension without pay pending the conclusion of the investigation and conclusion of the court case, it ended by warning the defendant staff not to collaborate with any of the persons named in the memo, that is Exhibit CWC. The question to ask at this juncture is Exhibit CWC addressed to the claimant personally or copied to him? What is the means of communication between the defendant as employer and the claimant in person, being an employee? And the letter of suspension regarding a particular staff take the form of memo addressed to all staff? I answer all these questions in the negative. Employment relationship is between the defendant and the claimant personally. When he was employed, the letter of employment was addressed to him personally. When the appointment was confirmed, the letter of confirmation, that is Exhibit CWCB, was addressed to the claimant personally. Why then should a letter of suspension not be served on the claimant personally? I am at one with the argument of the learned counsel to the defendant that Exhibit CWC is nothing but a memo addressed to the defendant's members of staff as a warning, which cannot serve as a letter of suspension to the claimant. It is the law that a letter pasted on the notice board of an organization is a letter to the general public and not to anyone in particular. I refer to the case of Selcon Tannery Limited and versus Abubakar and others. Citation supplied. There to be a suspension, an employer must give an employee a clear and concise reasons for the offending suspension. Additionally, an employer must send an employee a letter of suspension, which letter shall state whether the suspension is definite or indefinite. And in the instant case, the claimant's failure to tender a letter of suspension is fatal to the claimant's case. I so follow therefore from the above finding that the claimants having failed to prove the suspension by the defendant cannot claim salaries for the time of the purported suspension, May 2016. It is the law that the onus is on the employee that claims for unpaid salaries to prove that the employer employed him on a stipulated salary and that he worked for the employer during the relevant period. It is for the employee follow therefore from the above finding that the claimant having failed to prove his suspension by the defendant cannot claim salaries from the time of the purported suspension to May 2016. It is the law that the onus is on the employee that claims unpaid salaries to prove that the employer employed him on a stipulated salary and that he worked for the employer during the relevant period. It is for the employer to prove not only that he paid the employee his salary for the work done by the employee in the relevant period, but also how much the salary that he paid the be force. I refer to the case of Monica Soapins Limited against all conditions of life. The instant case, the claimant has failed to prove that he was suspended by the defendant for the relevant period. Neither has he proved that he went to work but was not allowed to work during the same period. This being the case, I find that reliefs A and B have failed and are accordingly dismissed, and I so hope. The claimant also prayed under relief C for a declaration to the effect that his arraignment was wrongful, nothing but an act of vendetta, unjustifiable victimization, and persecution. The claimant did not adduce any evidence to prove to this court that the defendant had a hand in his prosecution before the Ikeja magistrate court, other than reporting a case of theft of books and requesting for investigation from the police. Generally, it is the duty of citizens of this country to report cases of commission of crime to the police for their investigation. And what happens after such report is entirely the responsibility of the police. The citizens cannot be held culpable for doing their civil duty unless it was shown that it was done malafide. I refer to the case of Ajemi Rokun against Commercial Bank Limited and another, Ecobank versus Duforo and another. This being the case, I find that a relief C is not grantable and I so hope.
As it go, please.
Relief D and E, reliefs D, E, and F are ancillary to the main reliefs. It is the law that where a principal relief for declaratory order pays, any relief based on that declaratory order must also pay. I refer to the case of Fudiu and others versus Ogudu, McDonald Scientific Emporium Limited versus Access Bank Limited.
As it go, please.
Citations of life. This being the case, I find that reliefs D, E, and F have failed and are accordingly dismissed, and I so hope. In the final analysis of all the reasons stated, I find no merit in the claimant's case and same is accordingly dismissed. Accordingly, I make no further proposals.
As it go, please, my lord.
As it go, please, my lord.
As it go, please. As it go, please, my lord. My lord.
Yes?
Yes. My lord.
Yes. Yes.
I noticed that the government just read, sir. The ex-marketing manager is Julius Inu, not Ajibade Adefoju. Adefoju is the ex-driver. When
reading the parts of the case, there was a mix-up in the parts of the case.
Very well, my lord.
And it will be corrected.
Thank you, my lord. Thank you very much.
Thank you.
Thank you, sir. I'm most grateful.
Next, registrar.
Suit number NITN/LA/425/2018 between John T.P. Francisco L. Ravelli. L. Ravelli, are you there? And Digisteel Integrated Services Limited. My lord, the claimant is present. Mr. Ravelli, can you please wave your hands?
Yes. Claimant present.
Defendant is absent, sir.
Defendant absent. Presentation of counsel.
May it please the court, Olurotimi Aju. Olurotimi Aju.
Yes.
appears for the claimant.
Okay.
Oh, okay. Respect to
Yes.
your lordship.
Yes.
I am H. Yusuf.
H.
H. Yusuf, your lordship.
Okay.
Holding the brief of Mr. M. Alaya for
I cannot see you, Mr. Yusuf.
I'm online, your lordship. Using my hand.
Yes.
Very well.
What is the brief of
Mr. M. Alaya for the defendant?
Mr. Alaya?
Yes, your lordship.
Okay. Matter is for judgment. Judgment is ready. I will read the introduction. The brief part of the case. I will skip to read the decision portion. Go this way. The claimant commenced this suit against the defendant via a complaint, statement of facts, and other accompanying processes dated the 13th of August 2018 and seeks for the following leaves. 1. A declaration that the defendant breached the terms of its contract with the claimant by failing and refusing to pay the claimant his full entitlements and wages as and when due from September 2015 till 17th of August 2017 by failing to agree and apply a yearly inflation index on the claimant's salary from the effective date of the contract, 17th of August 2017, by failing to pay service charge on the claimant's residence since December 2015, by failing and to assign the claimant with tax consistent with the contract, and by failing to pay for the claimant's unutilized vacation days and insurance. 2. A declaration that the claimant is as of May 31st, 2016, entitled to be paid the sum of $282,337 US in being the outstanding remuneration comprising of arrears of salary from September 2015 to May 2016, payment in lieu of 89 unutilized vacation days, inflation increment, and medical insurance. 3. A declaration that the defendant's action consisting of its failure to pay to the claimant his full entitlements and wages as at when due, its failure to agree and apply a yearly inflation index on the claimant's salary, its failure to pay rent and service charge on the claimant's residence when due, its failure to assign the claimant's task consistent with the contract and undermining the claimant's unutilized vacation days and insurance amount to intolerable work conditions, treatment, and unfair labor practice. 4. A declaration that the defendant constructively terminated the claimant's employment by subjecting the claimant to the foregoing intolerable work condition, mistreatment, and unfair labor practice, and failing to put an end to same, despite the claimant's several complaints. 5. A declaration that the claimant is, by virtue of the defendant's constructive termination of his employment, entitled to be remunerated for the unexpired term of the contract. 6. An order directing the defendant to pay to the claimant the sum of $282,337 US, being claimant's outstanding remuneration as at 31st of May 2016. 7. An order directing the defendant to pay to the claimant the sum of $537,535.5 US, being remuneration for the remaining term of the claimant fixed term contract, that is from 1st June 2016 to 16th of August 2017. Number 8, an order directing the defendant to pay to the claimant damages in the sum of $100,000 for loss of income and reputational damage suffered by the claimant on account of the defendant's breach of its obligation under the contract. 9, an order directing the defendant to pay to the claimant interest on the sum claimed in paragraph 6 above at the rate of 21% per annum from 1st June 2016. 10, an order directing the defendant to pay interest on the sum claimed in paragraph 7 above at the rate of 21% per annum from 17th of August 2017. Number 11, an order directing the defendant to pay to the claimant solicitors and to pay the claimant solicitors fee in the sum of $15,000 and other costs incurred by the claimant in prosecuting this action on a full indemnity basis. Now, the brief fact of the case. The claimant, who is a marine engineer and also the managing director of shareholder of the defendant, alleged that the defendant breached the terms of its contract with him by failing and refusing to pay to him his full entitlement and wages as and when due. In the case of the defendant, that it is not liable for the claimant's claim because it was the claimant who terminated his contract by his letter dated 30th of April 2015, and that no new contract was executed between the parties thereafter. And to the defendant, the contract was frustrated as a result of suspension of the lease agreement. As a result of the suspension of the lease agreement between the Nigerian Navy and Herima Nigeria Limited, HNL, the claimant's erstwhile employer, in respect of Ogogoro Island, which property the defendant purchased from HNL through the claimant. The defendant also stated that it is not liable to pay to the claimant any money whatsoever because the contract of employment was terminated when the claimant tendered his resignation letter and no new contract was executed between the defendant and the claimant on any basis whatsoever since the said action. The defendant also stated that the claimant is not entitled to any amount of money or compensation, as no money was ever made by the claimant's management throughout the creation and the inception of the company and the project which was initiated by the claimant. The crux of the defendant's case is therefore there is no valid contract between the parties that can be a ground for any enforcement by the claimant, and that if any, same has been eroded by the act of frustration due to the forceful takeover of the project site by the federal government. The court's decision. After careful consideration of the processes filed, the evidence adduced, the submissions of parties, and the written addresses, and the authorities cited in support, I find that the claimant's case is founded on breach of contract, based upon which the claimant seeks for 5 declaratory reliefs and 6 suspension orders. Now, the sole issue for the determination in this case is whether, having regard to the evidence and facts for this court, the claimant is entitled to the reliefs claimed in this suit. It is not in dispute that the employment relationship between the parties herein is governed. It is not in dispute that the employment relationship between the parties herein, as well as the terms and conditions thereto, are governed by Exhibit C1. It is the law. It It is the law that the terms of a contract of the parties are treated with sanctity, with some sanctity. It is the law that terms of contract. It is the law that terms of a contract between parties are treated with some degree of sanctity. And if any question arises with regard to the contract, the terms in any document that constitutes a contract are invariably the guide to its interpretation. See the case of Federal Polytechnic, Ida and another against Idigbe, Anya Obunam against Oscar and others. It is also the law that a court must confine itself to the terms of contract of service which provide for their rights and obligations. See the case of Pakuade against OAW, Obapemi Awodo Teaching Hospital Complex Management Forms, citation supply. It follows therefore from the foregoing authorities that this court must confine itself to the contents of Exhibit C1 in resolving the issues in controversy between the parties here. It is not in dispute that the claimant was employed by the defendant as a managing director for an initial peak term of 5 years with effect from 1st September 2012. See clause 1.2, see clauses 1.2 and 16.2 of Exhibit C1. By paragraphs 17.2 of Exhibit C1, either party may at any time end the same agreement by giving to the other 3 months notice in writing, which notice shall contain the reason for the termination of the contract. Now, the defendant's contention is that the claimant had resigned from the defendant's employment by a letter dated 30th of April 2015. See paragraphs 5 and 6 of the statement of facts. The claimant denied the part of resignation, but admitted that he wrote Exhibit D8 where he complained of various actions of the defendant's chairman which undermined his person, his role as managing director, and a breach of the terms of conditions contained in Exhibit C1. Claimant also averred that he remained the defendant's MD, managing director, until May 2016, and the defendant treated him as such by paying him salaries for the months of July, August, November, August and November 2015, and December 2015. In fact, and that the defendant continued to hold him out to third parties as its managing director subsequent to Exhibit D8. See paragraphs 4, 5, 6 of the claimant's reply to the statement of defense. Now, I have painstakingly examined Exhibit D8. It is dated 30th of April 2015. It is headed private and confidential. It is addressed to the chairman. It does not contain the full name of the author as it is unsigned. From the contents, no notice of resignation is given as required under paragraph 17.2 of Exhibit C1. What I take from Exhibit D8 is therefore that the author is merely channeling his grievance to the chairman and also said he find a time to say goodbye because he has no reason to stay any longer. The question to ask at this juncture is, does Exhibit D8 qualify as a letter of resignation in view of paragraph 17.2 of Exhibit C1? It is the law that a resignation from employment is by giving of required length of notice or payment in lieu of notice. See the case of INEC and others versus Chief T.A. Uji and Zubairu and another versus Mohammed and others, citation supply. Now, the conduct of the parties herein subsequent to the issuance of Exhibit D8 clearly indicates that Exhibit D8 was not intended to bring to an end the employment relationship between them. Exhibit D8 also belongs to the category of documents that must be signed for them to be valid in the eyes of law. The perusal of Exhibit D8 reveals that it is unsigned. The law is that an unsigned document is worthless paper. See the case of Davidson and others versus INEC, on Omega Bank PLC, Omega Bank Nigeria PLC, and against OBC Limited, citation supply. For all the reasons stated, I find that Exhibit DA does not qualify as, does not amount to a letter of resignation, and I so opt. The defendant averred at paragraph 4.1 of the statement of defense that it is a mere project company that was set up for the purpose of the project at Ogogoro Island, which has been taken over from the defendant in 2014. See paragraph 4 of the statement of defense. The defendant argued that the claimant was appointed by the stakeholders to manage the project and the site at Ogogoro Island. Hence his appointment as the defendant's managing director, and that the claimant has confirmed under cross-examination that the defendant is a project site, that the possible takeover of the island by the federal government of Nigeria determined the employment contract between the parties by prostration, i.e. by operation of law. That these facts were not denied by the claimant in his reply to the statement of defense, and that they are therefore deemed admitted. The defendant therefore contended that the possible takeover of the project side of the defendant and the eventual shutdown of the business activities of the defendant clearly discharges the parties to the contract from further obligations under A. See generally paragraphs 5.12, 5.13, 5.14, 5.15, 5.16, 5.17, 5.19, 5.21 to 5.25 of the defendant's final written address. The claimant's reaction in this regard is that Ogogoro Island was not contemplated under Exhibit C1, the employment contract between the parties herein, and that the possible takeover of the said island by the federal government did not constitute a fundamental disruption of the contract. That the claimant had averred at paragraph 3 of the statement of facts that the defendant is a company duly incorporated in Nigeria and carries on business inter alia as a provider of complete onshore and offshore engineering, construction, and installation services in the oil and gas industry, that the said averment was admitted by the defendant at paragraph 1 of the statement of defense. That the alleged takeover of Ogogoro Island by the federal government of Nigeria could not have frustrated the 5-year fixed-term contract, employment contract, because the said island was not contemplated in the said contract, and this was confirmed by the defendant's witness under cross-examination. Now, as rightly submitted by the learned counsel to the claimant, in order to resolve whether the employment contract between the parties herein was frustrated by the possible takeover of Ogogoro Island by the federal government or not, recourse should be heard, and I add, can only be heard by reference to Exhibit C1. I say so because of the tried position of the law that contracts of employment, like all other contracts, their creation and termination are both subject to the general principles governing law of contract. Hence, where the contract of employment is in writing, as in the instant case, the parties are bound by the express terms and conditions stipulated therein. See the case of Keystone Bank Limited versus Clark, Olanian and others versus Unilag and another. Citation supply. It is also the law that a written agreement entered into by the parties is binding on them. where there is any disagreement between the parties to such written agreement on any particular point, the only reliable evidence to resolve the claim is the written contract of the parties. The reason being that where the intention of the parties to a contract are clearly expressed in a document, the court cannot go outside the document in search of another document not forming part of the intention of the parties. In the case of UBA PLC against Ajebule and Anyebunam versus Osaka and others, citations of line. Now, a careful perusal of the employment contract between the parties herein, that is Exhibit C1, reveals that no mention was made of Ogogoro Island. The claimant was simply appointed as the defendant's managing director for a fixed term of 5 years. See paragraphs 1.1 and 1.2 of Exhibit C1. Although the claimant's witness has admitted under cross-examination that the defendant was incorporated for the purpose of carrying out the project transferred to it by Erema Nigeria Limited, that is Ogogoro Island, these, to my mind, cannot vary the content of Exhibit C1. It is the law that parole evidence cannot be admitted to add, to vary or contradict a written instrument. In the case of Olaleki against Afro-Continental Nigeria Limited, citations of line. There is no evidence before this court whatsoever to prove that the defendant was solely incorporated for Ogogoro Island project. The claimant abide at paragraph 3 of the statement of facts. Thus, the defendant is a company duly incorporated in Nigeria with the registration number RC 510051 and carries on business inter alia as a provider for complete onshore and offshore engineering, construction, and installation services in the oil and gas industry. The defendant has its registered office address at number 38 Byron Street, Wuse to Abuja, and maintains a corporate office at number 13 Adekule Paduyi Way, GRA Ikeja, Lagos. End of quote. Now, the defendant abide at paragraph 1 of the statement of defense, thus, and I quote, the defendant admits paragraphs 1, 2, paragraphs 1, 3, 4, 5, 6, 7, 31, 32, and 33 of the statement of facts. Now, having clearly admitted paragraph 3 of the statement of facts that it is a project company in oil and gas industry, the defendant cannot turn around and argue that it was purposely incorporated for Ogogoro Island. The law is that where an admission is made in the pleadings, the party making same is bound by it as parties are bound by their pleadings. And matters admitted by the parties require no further proof. See the case of Apraf Came Limited and Oedui and Adeoye and others against Olofo and others, citations of line. It flows therefore from the foregoing authorities that the defendant, having admitted paragraph 3 of the statement of facts, which describes who the defendant is, cannot turn around to claim that the defendant was only incorporated to execute Ogogoro Island project. For all the reasons stated, I find that the defendants, having not been solely incorporated for the project at Ogogoro Island, the takeover of the said island by the federal government cannot frustrate the employment contract between the parties herein, and I so hold. The defendant also argued at paragraphs 5.27 to 5.29 that the payments it made to the claimants after December 2016, after December 16, 2014, were ex gratia or gratuitous, as the defendant has no legal obligation to pay to the claimant any form of remuneration. The claimant's reaction in this regard is that this argument was never pleaded by the defendant in the statement of defense, and is nothing but counsel submission, which in law cannot take place of legal force. At one, with the learned counsel to the claimant in this regard, as the arguments at paragraphs 5.26 to 5.28 were not supported by any abatements in the pleadings and are therefore nothing but counsel submission, which cannot approximate to an abatement in the pleading or a legal form. It is the cardinal principles of law. It is the cardinal rule of pleadings that material facts to be admissible in evidence must be pleaded. As a result, neither party will be allowed to raise at the trial of a suit an issue of fact which he has not pleaded. See the case of Ifelaye versus Onokutu and Apambio versus Apambio Okajibu and others versus Chidi and others, citations supplied. These being the case, the arguments of the learned counsel to the defendants at paragraph 5.26 to 5.29 of the final written address are hereby discountenanced, I find, and I so hoped. Throughout the abatements contained in the defendant's statement of defense, nowhere have the defendant specifically denied the claimant's claim for the unpaid salaries and other entitlements. The defendant alleged misrepresentation of facts against the claimant at paragraph 4 of the statement of defense, which allegedly left a huge economic loss at the side of the defendant, which made it incapable of making a dime since its inception under the watch of the claimant. This, to my mind, does not amount to a specific denial of the claimant's claim in the pleadings. It is the law that the law is tried and well settled that a defendant's pleading should only respond to statement of facts about on the claimant's statement of claim. It is not for the defendant to set up facts which will convey that it is not just setting up a defense to the claimant's case, but setting up a new case of its own. A defendant is only entitled to do this when setting up a counterclaim. See the case of Anekwe and another versus Mweke and Longe versus Post Bank Nigeria PLC, citation supply. I therefore agree with the submission of the learned counsel to the claimant at paragraphs 5.1 and 4 of the final written address that the defendant did not controvert the pleadings nor the evidence adduced by the claimant at the trial. I find and I so hold. The claimant pleaded at paragraphs 11 to 24 of the statement of facts, which are in exact terms with paragraphs 11 to 24 of the claimant's witness written statement on oath, that the acts and omissions of the defendant in this case were targeted at making the claimant's working condition as managing director intolerable, and for which the claimant was compelled to quit the defendant's employment. In support of the said abatements, the claimant tendered Exhibit C1, C2, C3, C4, C5, C8, and C9, which revealed the conditions in which the claimant was at the material time and the efforts he made to have the defendants ameliorate his situation. Now, a combination of all these facts contained in the said exhibits kicked the claimant out of the defendant's employment, and for this he treats his resignation as constructive discharge. The claimant also alleged that the defendant had undermined his role as managing director, as since May 2016, the defendant did not assign him with tasks consistent with his role as managing director. Facts relating to these are above at paragraphs 19, 20, 21, and 22 of the statement of facts and the corresponding paragraphs of the claimant's witness written deposition. In support of all these, the claimant tendered exhibits C6 and C7. At paragraphs 26 of the statement of facts, the claimant averred that when he wrote and when those intolerable acts of mistreatment and unfair labor practice persisted, he became constrained to refrain from work on May 31st, 2016, and treat those acts as constructive termination of his employment by the defendant. Now, the defendant did not react to the claimant's argument of constructive termination in his reply or point of law to the claimant's final written address. Now, constructive dismissal or termination is when an employee resigns within a reasonable period of time in response to the employee's fundamental breach of an express or implied term of the employment contract. In other words, the employee is forced to resign because the employer has committed a serious breach of employment contract. The employer's breach must be an effective cause of the employee's resignation. To successfully prove constructive termination, an employee must resign. The employer must commit a fundamental breach of the employment contract, and the resignation must be in response to the breach. The resignation must be in response to the breach, and the resignation must take place within a reasonable period of time after the employer's breach. In Ms. Ebere Okoji and Standard Alliance Life Insurance Company Limited, citation supply, this court, Honorable Justice B.B. Kanyip, as he then was, now the President of the National Industrial Court of Nigeria, held thus, under a quote, globally and in labor/employment law, constructive dismissal, also referred to as constructive discharge, occurs when an employee resigns because his/her employer's behavior has become intolerable or heinous, or made life difficult that the employee has no choice but to resign. Given that the resignation was not voluntary, it is in effect a termination. In an alternative sense, constructive dismissal or constructive discharge is a situation where an employer creates such working conditions that the affected employee has little or no choice but to resign. Thus, where an employer makes life extremely difficult for an employee to attempt to have the employee resign, rather than outright firing the employee, the employer is trying to create constructive discharge. The exact legal consequences differ from country to country, but generally a constructive dismissal leads to the employee's obligation ending and the employees acquiring the right to seek legal compensation against the employer. The employee may resign over a single serious incident or over a pattern of incidents. Generally, the employee must have resigned soon after the incident. See generally Western Excavating versus Schaff or Ladosu, Oguni, Nigerian Labor and Employment Law in Practice, Folio Publishers Limited, Ikeja, 2004, second edition, at paragraphs 462 to 464. End of quote. In the instant case, evidence was laid by the claimant, which proved the fundamental breach of the express term of the contract. The claimant, however, failed to show that he resigned within reasonable time after the defendants committed the fundamental breach. This being the case, I find and hold that there was no constructive termination in this case. The claimant simply stopped going to work and treated the contract as repudiated. To have succeeded in making a case of constructive dismissal, the claimant should have resigned from the defendant's employment within a reasonable time of the breach. It is clear, not in dispute, that the claimant stopped going to work from May 31st, 2016, owing to the defendant's breach of some of the fundamental terms of the contract. The claimant cannot, in my view, claim for salaries and other allowances, other entitlements beyond 31st May. He must, because he neither served the defendant beyond that date, nor did the defendant terminated the claimant's contract. It is the law that an employee cannot claim salary/allowances for a period he did not work. This is the case of Abdul Rahim and others, as is Olupeba and others. The claimant is only entitled to his outstanding salaries and the allowances that were due but unpaid by the defendant as at the end of May 2016. I find and I saw. The claimant prays for 5 declaratory reliefs and 6 consequential orders. Now, declaratory reliefs are not granted as a matter of course. An applicant for same must lead evidence to prove his entitlement to the said relief. The claimant has led evidence to prove his entitlement to relief 1, and for the reasons stated herein before, I find that relief 1 succeed and I so hold. Relief 2 is for declaration to the effect that the claimant is, as at 31st of May 2016, entitled to be paid $487,337 United States dollars, being the claimant's outstanding remuneration, which comprises of salary arrears from September 2015 to May 2016, payment in lieu of 89 unutilized week and vacation days, inflation increment, and medical insurance. Now, the claimant's entitlement as per Exhibit C1 are pleaded at paragraph 7 of the statement of facts, which the defendant admitted at paragraph 1 of the statement of defense. The claimant abated at paragraph 12 of the statement of facts that he is being owed a total sum of $160,000 US as salaries exclusive of tax and inflation index. As at 31st of May 2016, the breakdown of the total amount is as follows. 1. September 2015, $25,000 US. December 2015, $10,000 US. 3. January 2016, $25,000 US. 4. February 2016, $25,000 US. Number 5. March 2016, $25,000 US. Number 6, April 2016, $25,000 US. Number 7, May 2016, $25,000 US. Now, the claimant abandoned of the statement of facts that he was paid $20,000 on April 19, 2016 by the defendant chairman. At paragraph 4 of the the claimant abandoned that the defendant never paid the agreed inflation index on his salary. At paragraph 15 of the statement of fact, the claimant abandoned that he is entitled to be paid the sum of $26,432 US as inflation increment as at 31st of May 2016. At paragraph 23 of the statement of fact, the claimant abandoned that as at 31st of May 2016, he was owed a total of 89 vacation days by the defendant and thus entitled to be paid $107,340 US inclusive of 2.5% inflation rate per annum. The claimant also abandoned at paragraph 24 of the statement of fact that he is entitled to be reimbursed for the cost of insurance policy taken out by him on March 2nd, 2016 in the sum of $8,565 US. These abandonments are in the same terms with the depositions contained at paragraphs 11, 12, 15, 23, and 24 of the claimant's witness written statement of oath. Now, the law is set that in labor relations, an employee can only claim if he or she shows entitlement, and this is by reference to the document or instrument that grants it. See the case of Muhammad Dungus and 7 others against ENL Consortium, good number NICL/LE/193/2014, the judgment of which was delivered on May 5th, 2015. Now, Exhibit C1 is the evidence of the claimant's entitlement, which entitlements were admitted at paragraph 7 of the statement of defense. The defendant did not deny owing the claimant's salary and arrears being claimed, and salary arrears being claimed under this relief. In proof of this relief, the claimant even tendered Exhibit C2, C8, C9, and C10. This being the case, I find that the claimant has proved his entitlement to Relief 2, and I so hold. Relief 3 is for declaration to the effect that the defendant's action amount to unfair labor practice. Claimant has laid evidence which proved that the defendant had breached the terms of the employment contract by failing to pay to the claimants and to pay the claimant's entitlement, yearly inflation index on the claimant's salary, service charge on the official residence, non-assignment of tax befitting the claimant's status, non-payment of the unutilized days and insurance. These being the case, I find that this relief succeeds, and I so hope. Reliefs 4 and 5 are for declaration to the effect that the defendant has constructively terminated the claimant's employment. I have already found and held that the claimant has failed to prove constructive termination. And this being the case, I find that relief 4 and 5 are equally paid, being ancillary to the main reliefs. And I so hold. Relief 6 is ancillary to Relief 2 in the form of consequential order. Having granted Relief 2, Relief 6 being ancillary to Relief 2 succeed and is hereby granted. Relief 7 is ancillary to Reliefs 4 and 5 which have not been proved by the claimant, and this being the case, I find that Relief 7 cannot be granted and is accordingly dismissed, and I so hold. Relief 8 is for damages for loss of income and for reputational damage. Relief 8 is damages for loss of income and reputation and reputational damage suffered by the claimant on account of the defendant's breach of its contractual obligation in the sum of $100,000 US. Now, loss of income is akin to loss of profit, which is in the class of special damages that by law must be specifically pleaded and strictly proved. See the case of Omino Z and First Bank Nigeria PLC. The claimant did not plead and prove the particulars of the loss to his income. Regarding reputational damage, there is no pleadings whatsoever, and there is also no evidence before this court to prove injury to the claimant's reputation occasioned by the breach of the contract to warrant the award of reputational damage. This being the case, I find that this relief, that is Relief 8, has failed and is accordingly dismissed.
As the please.
Of prejudgment interest at 21% per annum from June 1st, 2016, over the amount claimed under Relief 6. It is the law that for a party to claim, before a party can claim prejudgment interest, he has to plead not only his entitlement to the interest, but also the basis of his entitlement, either by statute or contract / agreement between the parties, or mercantile custom or principle of equity, such as fiduciary relationship. This is the case of AG Perero and Company Limited against Henkel Chemicals Nigeria Limited. The claimant did not prove his entitlement to this relief. It fails and is accordingly dismissed. Relief 10 is for interest on Relief 7, which are paid. Relief 10 accordingly paid and is accordingly dismissed. Relief 11 is for solicitors' fee and other expenses incurred by the claimant in prosecuting this action to the tune of 15,000 United States dollars. These are the claimant has abad. The claimant has abad at paragraph 31 and 32 of the statement of facts that he caused his solicitors to issue notice of arbitration in which the claimant suggested 3 arbitrators for the defendant to choose 1. And when the defendant failed to concur, the claimant sought the intervention of this court for the appointment of the arbitrator by filing suit number NICN LA/599/2016 between the parties herein, but this court declined jurisdiction and struck out the case. The claimant also tendered Exhibit C11, the notice of arbitration, and Exhibit C12, that is the ruling of this court in suit number NICN LA/599/2016. It is clear from the above exhibit that the claimant has, before filing this case, retained the services of legal practitioner for the issuance of the demand notice, notice of resignation, filing of suit number NICN/LA/599/2016, and the filing of the instant case. And all these actions attract expenses. I am therefore satisfied that the claimant has proved his entitlement to relief 11. I find and I so hold.
Please.
Some, in the final analysis, for all the reasons stated, I find that the claimant's case succeeds in part and only in terms of reliefs 1, 2, 3, 6, and 11. And for the avoidance of doubt, I make the following orders, all of which shall be complied within 30 days from the date of this judgment by the defendant. 1. The defendant shall pay to the claimant the sum of $282,337 United States dollars, which represent the outstanding remuneration of the claimant as at 31st of May 2016. Number 2, the defendant shall pay to the claimant the sum of $15,000 US, which represent the solicitor's fee and other expenses incurred by the claimant as per relief number 11. 3, failing any of the above, shall attract 25% interest per annum until the adjudged sums are fully paid by the defendant. Judgment is entered accordingly.
We are very grateful, my lord, for the well-considered ruling. May it please the court.
The last case.
Suit number NICN/LA/605/2018 between Sir Patrick Umo and Toyota Nigeria Limited. The parties are absent, sir.
Parties absent.
Yes, sir.
Claimant counsel.
Presentation of counsel. Unmute your device, counsel. We cannot hear you. Unmute your device.
Has the court please?
We can hear you.
With profound respect to this honorable court.
Yes.
Rebecca Aderoju.
Rebecca.
Rebecca Aderoju.
Okay.
Appearing with me is Silas Udo.
With?
Silas Udo.
With?
For the claimant. Over appearance for the claimant, sir.
Okay. Any appearance for the defendant?
Please the court, Olurotimi Aju for the defendant.
Okay. Yes. Matter for judgment. Judgment is ready. It will be delivered with the reliefs. I will read the introduction, the reliefs, and I will skip the submissions of counsel with the decision portion. It goes this way. The claimant instituted this suit by filing a general form of complaint dated the 3rd of December 2018 and statement of parts, other accompanying originating processes, and prayed for the following reliefs. 1. A declaration that the letter of summary dismissal dated dated 7th of March 2018, issued by the defendant and served on the claimant is invalid, illegal, unlawful, wrongful, and of no effect whatsoever. B. An order for the sum of 20 million naira as damages or compensation occasioned by acts of the defendant. The defendant filed its judgment of defense on 10th of January. Can we have silence, please? Defendant filed its statement of defense on 10th of January 2019, and the claimant also reacted by filing reply to statement of defense. At the conclusion of trial, parties were asked to file final written addresses. The brief part of the case before this court is that the defendant the claimant's case is that he was employed by the defendant on the 24th day of November 1997, and he put in 20 years of service for the defendant. The claimant averred that in all the 20 years of service to the defendant, he was never involved in any fraudulent activity that could bring down the image of the company, and that on the 27th of February 2018, he was given a query accusing him of indecent assault of one Miss Cynthia Obona. The claimant alleged that upon receipt of the said query, he responded to the issues raised to the effect that the said Miss Cynthia Obona and one Femi Adejuru, who were colleagues in the office, had a misunderstanding and were engaged in a quarrel, and that the said colleague, Mr. Femi Adejuru, was holding her leg, and in a bid to separate the two of them, he held Miss Cynthia Obona and had to free her from Femi Adejuru, but he rather hit the claimant in the stomach, which severe pain led the claimant to withdraw his hand quickly to attend to the stomach pains and unconsciously slightly bruised Miss Cynthia Obona's breast. The claimant averred that even the secret camera installed at all the sections of the defendant's office, including where the incident occurred, can provide clearer evidence confirming the claimant's part in the matter. That the claimant alleged that apart from the query that was given to him, no panel was set up to investigate the matter, and that even Femi Adejuru, who was directly involved in the matter, was not invited to state his case in the matter, and no witness was invited. Claimant averred further that from the query and his answer to the query, no other evidence or inquiry was carried out to confirm or discredit his report on the matter before the permanent and harsh decision was taken on him by dismissing him from office. The defendant's case is that the claimant was employed as an office assistant by the defendant on the 24th of November 1997 by virtue of letter of appointment, and that on 27th of February 2018, The claimant assaulted and sexually harassed Ms. Cynthia Obona, a staff of the defendant, in the workplace. The acts of sexual harassment perpetuated by the claimant on that day involved holding on to Ms. Obona amorously and inappropriately despite her protest, throwing ferocious punch at her breast and threatening to suck her breast next time. The defendant alleged that the claimant further threatened that some supernatural harm will befall Ms. Obona within 2 days if he dared to make a report on the incidents. The defendant alleged further that Ms. Obona made a formal complaint of the incident to the defendant's management, who confronted the claimant with the grave allegation made against him and gave him the ample opportunity to respond to them. To the defendant, the claimant's response were, however, considered unsatisfactory by the defendant, and the claimant was consequently summarily dismissed by the defendant's letter dated 7th of March 2018, and that upon the claimant's dismissal, the claimant was offered all his accrued remuneration up to and including the date of the letter of summary dismissal, and was subsequently invited to collect a check of 26,989 naira 95 kobo, which was his outstanding entitlement. The claimant visited the defendant's office but refused to collect the check, to accept the check. Now the court's decision. After careful consideration of the processes filed, the evidence adduced, and the submissions of counsel, the claimant's case is founded on wrongful dismissal, based upon which the claimant prayed for one declaratory relief and consequential order. Before I proceed to determine the merit of the claimant's case, I need to point out here that the learned counsel to the claimant does not seem to appreciate the fact that there is a world of difference between invalid, illegal, or unlawful dismissal on the one hand and wrongful dismissal on the other hand. In a master and servant relationship, such as the instant case, a dismissal of employee by the employer cannot be declared null and void, invalid, illegal, or unlawful. Where the case succeeds, the dismissal will only be declared wrongful, and the employee's remedy is in damages. See the cases of Kato versus CBN, Osape versus Nigerian Paper Mills Limited, and Osisanya and AfriBank. The situation of payment in lieu or notice will apply where the court made a finding of wrongful dismissal in favor of the servant. Where, however, a court has made a finding that the dismissal or termination of the servant is null and void, there is no dismissal at all or termination. What the employer did is therefore a nullity. See the case of UTC against Mokurudu, Malome, and Waik. Citations supplied. Now, during trial, the claimant indicated his intention to raise objection to the admissibility of Exhibit T7, the defendant's handbook, and said he would raise him in the final address. The claimant argued at paragraph 6.1 of the final written address that he is objecting to the admissibility of the said exhibit on the ground that the claimant was served with the exhibit on the day it was tendered and it was not front-loaded, which violated the extant rules of this court. The defendant reacted to the objection in its reply on point of law. The defendant averred that the claimant gave notice to the defendant to produce the staff handbook at paragraph 14 of the reply to statement of defense. And the said handbook was tendered pursuant to the said notice to produce. That a document that is not front-loaded is still admissible, and that it is the Evidence Act, not rules of court, that governs admissibility. That there is no provision in the Evidence Act that says that a document that is not front-loaded is inadmissible, and that the Act does not contemplate concluding of documents after a notice to produce has been served on a party. Now, as rightly argued by the learned counsel to the defendant, it was the claimant that pleaded the staff handbook, Exhibit D7, and put the defendant on notice to produce same at the trial. It followed therefore that the defendant was right to tender the said handbook without even concluding it. Besides this, the staff handbook is relevant to the issue before this court. It is tried that the test of admissibility is relevant. Once a document is relevant to the proceedings, that document will be admitted as it has passed the test of admissibility. See the case of Ogujipo and Essex Bank Limited. Citations supply. The claimant also argued that the defendant should tender the original copy of the stand handbook, not a copy, and that it was not the one given to the claimant. The claimant, however, failed to tender the one given to him by the defendant to convince this court that Exhibit D7 is indeed not the defendant's staff handbook. For all the foregoing reasons, I find no merit in the claimant's objection to the admissibility of Exhibit D7. It is accordingly overruled, and I so hold. Turning to the merit of the claimant's case, the main bruise of the claimant is that his summary dismissal by the defendant is wrongful in that, apart from the query given to him by the defendant, no panel was set up to investigate the matter, and none of the persons directly involved in the matter was invited to hear from them. The fulcrum of the defendant's argument is that upon receipt of the formal complaint of sexual harassment against the claimant from one Ms. Cynthia Agona, it confronted the claimant with the same allegation and gave to him ample opportunity to respond to same. That having considered the claimant's response to the query unsatisfactory, the defendant summarily dismissed that claim by Exhibit C4. Now, from Exhibit C4, the claimant's summary dismissal was predicated on 4 grounds, namely sexual harassment of a female colleague, gross insubordination by demeaning the office of the managing director, and using abusive and foul language in office. The law is settled that an employer or servant who complains that his employment has been wrongfully terminated or abruptly brought to an end must found his claim on contract of service and show in what manner the wrong was done. He must plead and prove the contract of service, which is the bedrock of his case. It is not in principle for the employer who is a defendant to prove that the termination or dismissal was not wrongful. See the case of Ahmed versus ABU and another, First Bank Nigeria PLC versus BAM, and Anaja versus UBA PLC. Now, from the state of the pleadings filed by an exchange between the parties, herein, I find that the following parts are not in dispute. A, on February 27, 2018, the claimant was issued a query by the defendant over an allegation of sexual harassment and wrong use of word to a colleague in the office environment, Exhibit C2. B, the claimant responded to the said query by Exhibit C3. C, the defendant, upon being dissatisfied by the claimant's response, summarily dismissed the claimant by Exhibit C4. The issue in dispute between the parties is on the procedure adopted by the defendant in summarily dismissing the claim. The claimant's contention, as can be gathered from paragraphs 9 and 10 of the statement of facts and paragraph 6 and 7 of the reply to the statement of defense, is that apart from the query served on him and the response he made to the query, no panel was set up by the defendant to investigate the allegation. No opportunity was given to him to appear before the panel to state his case and to be able to ask questions. The claimant pleaded and tendered his letter of appointment, which was admitted and marked as Exhibit C1 at page 2 of which at page 2 incorporated the terms and conditions contained in the Defendant Staff Handbook, Exhibit D7, into the agreement between the claimant and the defendant's hearing. The defendant's response, as can be gathered from paragraphs 8, 9, and 10 of the Statement of Defense, is that the claimant was given fair hearing before his summary dismissal, that the claimant was confronted with the allegation of gross misconduct made against him via Exhibit C2, that he was given an opportunity to respond to same, and that when the defendant was not satisfied with the response made, it subsequently dismissed the claimant. That before reaching the decision, further evidence was taken from the victim and one Femi Adejuri, and that the same Femi Adejuri was queried to by Exhibit D2, and he responded by Exhibit C3, consequent upon which he was warned by Exhibit D4. That the evidence gathered from the victim, Femi Adejuru, and other members of staff of the defendant established the allegation made against the claimant. Now, the general rule is that an employer is not bound to follow a procedure, a particular procedure. Sorry, Council, we have power outage. Using the light. Continue. Now, the general rule is that an employer is not bound to follow a particular procedure in summarily dismissing an employee. There is, however, a long line of judicial authorities identifying some exceptions to this rule. In the case of Audu versus Petroleum Equalization Fund Management Board and another, the Court of Appeal, per Odili JCA as his then was, held at page 18 to 20, pages 18 to 20, paragraph C. Thus, at common law, an employer is not obliged to follow any particular procedure in summarily dismissing his servant. But where the dismissal is in breach of a fundamental term, such as the giving of sufficient notice to terminate the contract, the servant has to accept the fact that the contract is at end and his only remedy lies in suing for wrongful termination of his contract of service. An employer's right of summary dismissal must arise from the terms expressed or implied in the employment contract. However, the master and servant relationship, being basically one founded in on contracts and subject to the vagaries of the ordinary law of contracts, the employer's right of summary dismissal can be achieved by the incorporation of work rules or collective agreement into the contract of employment. At common law, a master, at common law, in an ordinary master and servant relationship, let me come again. At common law, as a master, at common law, a master in an ordinary master and servant relationship always has the right to terminate the servant's employment on reasonable notice. Any ground which tends to show that the employee has outlined his usefulness or that his continued employment is no longer in the interest of the job. Any ground which tends to show that the employee has outlined his usefulness or that his continued employment is no longer in the interest of the job is a good ground. The general principle is that the employer to appoint. The general principle is that the power to appoint implied the power to remove. And so, where the power to appoint is silent on the power to remove, that will be implied. Although an employer is not bound to follow a particular procedure in summarily dismissing an employee, there is a long line of judicial authorities identifying some exceptions where to properly and effectively determine a contract of employment, the employer has to follow proper procedure. The following are the exceptions. A, where the contract itself made provisions for procedure to be followed. That procedure has to be followed to effectively determine the contract. B, where the statute regulated the appointment and dismissal of the servant, the requirement of the statute must be complied in that case. The master-servant relationship as what is known as statutory labor. In that case, the master and servant relationship as what is known as statutory labor. C, the other third category affects holders of office involving public function. Here, the rules of natural justice must be complied with in the dismissal. End of quote. Now, to determine whether the dismissal of an employee was correct or wrong, the terms of employment of the aggrieved employee must be examined to see whether the correct procedure was followed. See the case of AZ and Spring Bank citation supplied. Now, Exhibit D7 is the Defendant Staff Handbook, which contains the terms and conditions of the claimant's employment contract. Under Article 9, nature of offenses, the nature of offenses and the disciplinary procedure, the offenses are categorized into A, B, C, and D. From Exhibit C4, the defendant relied on category A, that is section 1, 3, 5, and 6, and category B, section 5 and 8. Now, under category A, section 1, 3, and 5, and 6 deals with general misdemeanors as may be found necessary to warrant discipline, insubordination, unruly behavior, and use of verbal or written foul language, respectively. The disciplinary procedure under category A provides thus: if a case of misconduct is established following the following procedure will apply, depending on the number of times a staff involved in a calendar year. A staff is involved in a calendar year. 1, verbal warning to be given if the nature of the offense is mild and staff involved is a first offender. 2, written query requiring written explanation to be given if the offense is of a nature requiring such. If found culpable, a written warning to be given. 3, second offense warning. 4, third offense final warning. 5, fourth offense minimum of 1 week suspension without pay, in addition to loss of salary increment due to annual appraisal. 6, fifth offense termination of employment. 7, however, any step in the procedure can be adopted if the gravity of the offense committed warrant such. Fact 8, final decision to administer 5 to 7 above shall solely be at the discretion of the management on recommendation. Now, under category B, item B at page 14 of Exhibit D7, offenses under section 5 and 6 are fighting within the office premises and sexual harassment / immoral behavior within the office premises, respectively. The disciplinary procedure provides thus: if a staff involved in any of the offenses listed in item B of this category, the following procedure will apply: to be investigated by a disciplinary panel to be set up by the management with representatives from admin / human resources and the department of staff involved at the least. If presence of staff involved at her duty post would impede the investigation process, he/she may be asked to proceed on suspension without pay pending the conclusion of the investigation. If not found culpable, the staff will be recalled from suspension and all due salary and entitlements paid. If however found culpable, disciplinary procedure 1 to 3 of item A above of item A 1 to 3 in item A of category B above will apply. The disciplinary procedure in 1 to 3 states thus: written query requesting for written explanation given to staff above. 2, termination or dismissal of the employment of staff above. 3, decision on second to be solely the prerogative of the executive management. Now, it is clear from the above provisions that from Exhibit D7, it is clear from the provisions of Exhibit D7 reproduced above that the maximum punishment for the infractions allegedly committed by the claimant in this case under 1, 3, 5, and 6 is termination of employment, not dismissal. With regards to 5 and 6, under item B, dismissal is the maximum punishment to be provided by the employer. However, before even proceeding to issue a query, the employer must set up a committee of investigation, a panel in the form of panel of disciplinary panel to investigate the matter. It is after the panel that if the committee finds the employee culpable, that issuance of query will follow. In the instant case, there is no evidence whatsoever that the said panel was set up by the defendant in this case. The defendant merely proceeded and issued query to the claimant hearing, and upon receiving the claimant's response to the query, the defendant termed the said response as unsatisfactory and proceeded and dismissed the claimant. This, in my view, is a clear violation of the provisions of Exhibit D7, which is the Defendant Staff Handbook. And this being the case, I find and hold that the dismissal, the summary dismissal of the claimant in this case is wrongful, and I so hold. The second relief claim for damages in the sum of 20 million naira against the defendant. Now, it is the law that the remedy available in the case of summary dismissal, which is found to be wrongful, without any more, is the payment of salary in lieu of notice. In the instant case, I have no option but to apply the law as it is. Accordingly, the claimant is here, the defendant is hereby ordered to pay to the claimant a 3-month salary, an amount equivalent to his 3-month salary as damages for the wrongful dismissal. Cost in the sum of 500,000 naira is also awarded the claimant against the defendant and shall be paid, all of which shall be paid on or before 30 days from the date of this judgment. Judgment is entered accordingly. I make no order for costs.
Most grateful for the well-considered judgment, sir. Most grateful, sir.
Yes, sir. That's all.
That is all for today, my lord.
Yeah, thank you for your time.
Yes, sir.
The court shall rise.
God.
So you are using the device.
Okay.
Listen now.
I'm going when they say call what?
In through device.
Through
Device audio.
device. Okay.
Audio.
Okay.
Then you press it.
So you press what? Device?
Yes, the device audio. Choose device audio. Choose device audio.
And
you press.
Press device
Audio.
Audio.
So once you do that, if you notice, when we're talking, my Lord said, we cannot hear you. This is because I muted it.
Okay.
So if I now start video, this is start video.
Okay.
Just press it. Yeah, don't show you so far.
Okay.
Okay. Yes.
Okay.
But if you want to join without showing video, just do stop video.
Then
so unmute, start video.
Okay, you unmute. Okay.
Yes. Unmute. And then start video.
Then
video.
Start video.
That is after the medium, yeah, it's all for sure. So that's it. So when you are through, I could cross all day. It's okay. But man, I'm done. Yeah, sure.
Okay.
So you see, stop video. Stop. Unmute.
Thank you. Yeah.